Thank you very much, Judge Mackin. It's very nice to be here, especially standing in front of these two banners. In fact, both organisations of which I've been a director at one time or another. And I had to check my CV to remind myself how long ago it was that I was a volunteer in the Irish Refugee Council, but I'm not going to tell you. But I was surprised. It coincides vaguely with the entry into force of the Dublin Convention, so you can work it out. Yeah, so my topic is immensely broad, but I'm standing in front of the person who's going to speak about the most pressing issue of the day facing Europe, which is the Syrian refugee crisis. So I'm going to keep to my time. I have very detailed slides which are going to be circulated. So on occasion I may just zip through them and just alert you to the existence of certain interesting cases, but not necessarily discuss them. But as was stated, my task is the task that I've set for myself is to try to do a kind of a midterm assessment of the two courts that are now the two supranational refugee law courts. And I think the reason that this is an interesting moment to look at them is that we've had EU refugee law for some time, and the Strasbourg court has been faced with refugee-type cases for many years. But these are two very different institutions. And as Judge McCluskey made clear, they interact with each other. And that interaction, too, is a very interesting phenomenon. And in particular, I think what I'm interested in is the fact that refugee law is itself a regime, and the Refugee Convention. But that convention, as Professor Goodwin Gill stated in his presentation this morning, lacks supervision in the sense of having a dedicated court. I think I agree with him that that's not necessarily a deficit. But when we look to Europe, we have two supranational courts that are both faced with refugee law issues. They deal with them differently. And in that we have something that is a system which is full of opportunities, but it is not without risks and not without threats to the specificities of refugee law either. So what I'm going to focus on very much is the substantive questions about who gets protection, both in the sense of who is a refugee, who qualifies for subsidiary protection, and who is protected from refoulement under the ECtHR system. But I'll make a couple of additional comments about questions about access and asylum procedures that are going to be dealt with in workshops later also. So this is drawing on a whole lot of scholarship, not only mine, but I'll also mention this very useful handbook. There are copies outside, interestingly, only in German and French. So if you read those languages, by all means, grab them. It's full text online, but it's very helpful in setting out both the ECtHR and the EU standards in this field, sort of side by side in a very accessible way. And increasingly, there are scholars getting involved in this business of assessing the contribution of these courts as refugee law courts. Occasionally looking from the outside, like Mary Ellen Fullerton, they look on with envy and say, well, there are issues that have bedeviled asylum law in the US, which European courts are resolving quite progressively and simply. But I think from within, I think we also have to be a bit more critical and engage with the deficits in the European court's performance too. So as I said, I'm going to focus on these three regimes, the first being obviously EU law, the second being the Strasbourg system, and the third being the Refugee Convention, which for now means that I'm not going to say anything about other international human rights standards, although they are of added value in some areas. And I think we tend to overemphasize the Strasbourg court occasionally, and Strasbourg standards do fall quite considerably below international legal standards on some discrete topics, like on detention, for instance. I think the Strasbourg case law doesn't meet the standards under the ICCPR as articulated by the Human Rights Committee. So I don't think we should take it that Strasbourg is infallible in this field by any means. And these systems, as Judge McCluskey put very eloquently, interact. In fact, I would say there are various interfaces between EU law and the ECtHR, with which you're probably all familiar. For decades, Strasbourg has informed the general principles of EU law. It's built into the Charter that where the Charter reflects ECtHR articles, there should be a correspondence in their interpretation. unless, and EU law is entitled to set higher standards, which is crucial. And as we know, EU accession to the ECtHR is imminent. And all of this is reflected clearly in Article 6 of the Treaty on European Union now. And even notwithstanding that accession hasn't taken place, we also have a system where the Strasbourg court has kind of exercised a form of indirect control over EU acts, also for many years. When it comes to the Refugee Convention, though, obviously the starting point is that the EU hasn't ratified it. At one moment it said that it would, but that's never become a sort of a viable option, I think, although it would be a good idea. But what we do have is commitment to respect the Refugee Convention in the EU treaty and in the preambles to directives. And these are reiterated by the court too, the Luxembourg court, which refers to the Refugee Convention as the cornerstone of international refugee law. But I think we could pause, because one area where I think there is an institutional deficit is before the Luxembourg court, because one feature of the Luxembourg court is that interventions tend to be principally by national governments or routinely by the European Commission. And it's much easier for NGOs or international legal entities to intervene before the Strasbourg court than it is before the Luxembourg court. NULA is very good at getting into Luxembourg, but you have to be involved in the national court litigation at an early stage. And no one but NULA and the Air Centre are really that plugged into national litigation and are equally skillful in doing that. Which means that it is the voice of national governments which is often loudest in the Luxembourg litigation. And I think that should give us pause. It's something that scholars are starting to pay attention to now. So in terms of these interfaces then, I think we can see that that EU law and the ECtHR are quite heavily integrated. But of course there are distinctive features in EU law, like, as was mentioned previously, Article 18 of the Charter with the right to asylum, which is yet to be fully explored. Then in contrast, when we go to the Strasbourg court, what we see, and this is in sharp distinction to the Luxembourg court, is lots of cases, which are basically refugee cases. But the Refugee Convention isn't part of the body of law that's actually interpreted by Strasbourg. And this does make a difference in the Strasbourg case law, although the Refugee Convention is always acknowledged as part of the legal background of the contracting parties' legal obligations. And you do occasionally find references to, say, the notion of persecution in the Strasbourg case law and flagrant breaches that I'll talk about in a moment. So by the flagrant breach case law, what I mean is that the classic Strasbourg non-refoulement case is an Article 3 case. So an argument that returning somebody would expose them to a real risk of harms contrary to Article 3 of the Refugee Convention. In a handful of cases, individuals have sought to argue that other Strasbourg rights would be breached, like Article 8 or Article 6 on the right to a fair trial. And in those cases, Strasbourg has said that you have to establish a very high threshold, a very serious type of breach, a flagrant breach, or even a flagrant denial of the right in question, which has only been successfully argued in one Strasbourg case, which is the Othman Abu Qatada case on Article 6. So the Strasbourg case law has been concentrated on Article 3 as an absolute right, therefore triggering an absolute protection against refoulement. But occasionally in the background you'll get references to notions of persecution. So when we look at these two courts and actually look at their how they're situated, I think they're differently situated, and it can help if we're trying to understand their case law, if we understand those different jurisdictions. And I think crucially the fact of preliminary references is absolutely crucial to understanding the Luxembourg case law, because it's after all national judges who formulate the questions. And those questions can come from, nowadays, even the lowest tribunal in the land. And then the final determination remains in the hand of the national judge. So that notion of judicial dialogue is really central to understanding the endeavour of the Luxembourg court. Whereas, of course, Strasbourg is a court of last resort, although unfortunately for asylum seekers it often seems like the court of first resort if you're using Rule 39 to prevent refoulement, but it's meant to be a court of last resort. And then so these two courts are, let's say, different in terms of their output too, and I'm quite interested and can talk a bit more about that later. But one thing that would be suggested based on what we know about these two courts is that we would have good reasons to expect Luxembourg to be very bold and audacious in its rulings, because it doesn't really have anything to fear in terms of its own institutional position. So it's also very interesting to look at cases where the Luxembourg court has been quite tentative, let's say on asylum procedures, and question why that would be the case. Jens in his presentation suggested that Luxembourg was being cautious while the EU directives were being recast, because it wasn't going to give very bold interpretations at a moment when the EU legislature might undo what it, or take umbrage at the interpretations it was putting forward, which is a plausible institutional explanation, I think. Yeah, but as I said, really my key point here is just preliminary references are really the central institutional feature that one has to bear in mind in trying to understand the case law, particularly in this field, I think. And then when we look at the outputs, there's sort of a very well understood distinction when you go to read a Strasbourg case in contrast to reading a Luxembourg case, which might be very obvious if you do this, but it might be useful to reflect on also, which is that, well, the Luxembourg case law is one judgment. So it tends to be deductive, legalistic, and magisterial in style, elliptical, leaving lots of things out, contradiction riven into it, has to be agreed on by consensus. Judge Mackin could nod or shake her head as she wishes. So, but this is notoriously an institutional structure which doesn't produce voluminous output. It produces short, snappy, elliptical judgments, which don't particularly or at all really engage with the facts, because that's not what they're being asked to do. Whereas in contrast, Strasbourg is heavily fact-specific, inductive, casuistic, and doesn't commit itself to very broad propositions if it can avoid it in some instances. And this really does make a difference when we're asking how these courts interact or how they're setting standards for international refugee law. So those ideas I really just want to illustrate by looking at this particular area and this substantive question of who gets protection. And essentially we've had, I think now it's 8 or 9 cases on the qualification directive, and I'll just talk about a couple of them, but this is the overview. Elga Fadji's already been mentioned on subsidiary protection. We've had cases on cessation, on exclusion of Palestinians, on exclusion in the traditional sense under Article 1F, and then 2 cases on the meaning of persecution that I'm going to talk about, as well as some really interesting cases coming down the line. Following on from Elga Fadji, Diakite is also on Article 15C, but on whether international humanitarian law should be used to interpret the meaning of international or internal armed conflict. To which I think the answer is no, although distinguished colleagues of Judge McCluskey in the UK have thought otherwise, and in some other national judiciaries too. And then the HN opinion was already mentioned too, coming from the Irish courts. And then, again, down the line, very interesting reference from the Netherlands about what type of questions and evidence is appropriate to demand in cases about sexual orientation, persecution, and what types of process is compatible with human dignity and Article 4 of the Qualification Directive. And then an interesting case on exclusion too. Oh yeah, and then conscription and persecution, on which the UNHCR new guidelines came out today, I think. So really a question of central to refugee law on which UNHCR has offered guidance is also pending before the court. So on to my core question, and I'm just going to use the case law here to illustrate the kind of different approaches of the two courts in relation to understanding what these core topics mean. In the first of the cases, which was already mentioned, a German reference about the meaning of persecution, I think to understand the court, the case, you have to understand the national legal context. which is one in which the German Federal Administrative Court had taken quite a rigid view about religious persecution, drawing quite a sharp distinction between notions about religious expression in an external sense and religious convictions internally. And it tended to only find that there was persecution if the religious manifestation, external manifestation of religion, was being interfered with. And this notion was also applied in quite a rigid way. And my colleague Roland Bank, when he's been writing about these German cases, has really seen them as cases where the Luxembourg court has an opportunity to unfreeze the rigidities in German asylum law. And so that's the background to this reference. And essentially, the Advocate General in the case looked at the Strasbourg flagrant breach case law, which I don't think is the right place to look because it's not really directed to the question of what is persecution. The Advocate General also didn't actually cite the informal UNHCR intervention. So UNHCR can't intervene before the Luxembourg court, but it routinely issues statements on the internet which are clearly directed to the matter before the court. And some Advocates General cite them as informal amicus briefs, but not all. And the court essentially rejected the German approach to interpreting persecution, taking on this much more contextual examination in light of human rights standards on freedom of religion. So it seems, if one reads the case at face value, to reject the German approach. But interestingly, as I understand it, it hasn't had a profound impact in the German legal system, although I'm sure there are people in the room who are more expert on that than I am. And they seem to have folded it back into their original approach, in some cases at least, that have been decided since then. The Strasbourg flagrant breach test, as I said, in cases like this, had seemed to be setting such a difficult threshold to meet that actually the notion of persecution would be much broader than the notion of a flagrant breach of freedom of religion under the ECtHR standards. And I think that's something that's important to bear in mind. We sometimes tend to assume that the human rights protections are going to be broader than the notion of persecution under the Refugee Convention, but I don't think that's always the case. So there's an interesting case note on this religious persecution case, which you can have a look at. Also relevant then is the recent case of XYZ on persecution of LGBTI claimants, where you have criminal laws which criminalize either homosexuality or certain same-sex consensual sexual acts. And the court looked at a variety of references from different countries where there are different types of criminal laws, but all of them criminalizing some forms of some homosexual activity. And didn't say that the existence of those laws per se amounted to persecution, but it said that the existence of those laws certainly supported a finding that sexual minorities constituted a particular social group, and that if there was imprisonment attaching as a sanction to the breach of those laws, that would in and of itself amount to persecution. And it also rejected a line of argumentation which had been given some weight in some jurisdictions, which would be to say that it would be appropriate to inquire into whether if somebody lived discreetly in their country of origin and that could therefore avoid the sanction of the criminal law, that would mean that they didn't have a well-founded fear of persecution. And that line of argumentation was simply rejected. In fact, the Advocate General Sharpston in the case said it was simply the wrong premise, and the avoidability of persecution isn't salient in these kinds of cases, simply because one has a fundamental right to manifest one's sexual identity as one has a fundamental right to manifest one's religious identity. So I think this case, on the other hand, has been criticised, although it clearly is much more protective than the Strasbourg case law on returns in these kinds of instances, which would be F in the UK. And there's been an interesting discussion about whether the UK case of HJ and Iran is actually, well, it's certainly a more elaborately reasoned ruling. But that too, both cases I think have waded into an area where there's a variety of reasonable opinions about what is the best way of characterizing the harms involved, where you have homophobic laws and a homophobic society, and how should we expect judges then to assess what the persecutory harms are in instances where people may be able to avoid prosecution, but nonetheless you would want to be able to say that the social environment is persecutory. So there's been interesting reactions to both cases. I think reflective of the sort of lively debate that one gets with refugee law and the role of a lot of NGO activists and lawyers in the field who are quite vocal at articulating their points of view, and appropriately so, about whether these cases are correct or not. And in contrast, I think, I'll come back to that. I think what we see in these cases is that the very notion of persecution at the heart of the Refugee Convention, which can sometimes be criticized as a very regressive idea or based on a very outmoded notion of the refugee, is actually the site for very progressive contestation. And at present, that's a more fruitful place for making progressive movements in developing refugee law, certainly than the Strasbourg flagrant breach test. And so there is a question, well, should Strasbourg take this into account in its own flagrant breach cases? Or is this really just an area where we should acknowledge the distinctiveness of persecution and the distinctiveness of the Refugee Convention? And for that, I'll just leave that as a question for now. But I would say it's certainly the case that Luxembourg, whose job now is effectively to interpret the Refugee Convention, shouldn't be looking at the Strasbourg flagrant breach case law for guidance on these questions, because it's just not addressed to the same question as the question of what is persecution. So this is one of the areas where I think we have to be quite careful in saying we don't want convergence. There's actually good reason for divergent approaches between the two courts. When we look at subsidiary protection, just very quickly and sort of to conclude, obviously there is a distinctive, potentially distinctive EU-based protection in Article 15C, which if ever there was a hot potato thrown to the judiciary, it's that one. So it talks about an individual threat from indiscriminate violence, and then asks the judges of Europe and officials of Europe to make sense of that idea. And obviously they attempt to do that in El Ghafaji. And very clearly in El Ghafaji, the Luxembourg court says, well, these protections clearly go beyond the ECtHR, and they clearly go beyond the Refugee Convention. And the distinctiveness of Article 15C is that it basically gives an interpretation which, for Luxembourg, is to be made sense of, and the Advocate General struggles through this idea of indiscriminate violence and individual threat, has to be about the intensity of the violence. And only if violence in a particular area is extremely intense will it be characterized as posing an individual threat, and so protection under Article 15C is warranted. When the case goes back to the Netherlands, and I think this is often the interesting story and why the EDAL database is so interesting, the Dutch Raad van State, which is quite a conservative institution in some respects, says, well, yes, we were right, Article 15C means the same as Article 3 ECtHR, which is precisely not what the ECJ had said. And they said that was because the Strasbourg case law had since moved on. And all of this might seem like splitting hairs if it didn't actually matter to the question of who gets protection. And then the matter, indirectly in its own way, comes before the Luxembourg court, as Jens mentioned already. And in Soufi and Elmi, the Strasbourg court said, well, it's not for us to interpret EU law, but if we had to give a view, we would say that Article 15C and Article 3 protections are now analogous to one another. They're comparable with each other. So how should we reflect on that dynamic that we've seen? Well, certainly it's the case that the qualification directive embodies, well, what I've said here is uneasy compromise. Hot potato is probably better. And some governments in El Ghafaji invite Luxembourg to fold 15C back into Article 3. And they actually go to the Luxembourg court in some numbers and say, we never meant 15C to add any additional protections, in spite of the clear wording and every reasonable interpretation of that directive, which is why beware of what governments will argue, even in court proceedings. And Luxembourg rightly refuses to follow these governmental submissions and puts forward at least a workable understanding of Article 15c. Strasbourg, on the sidelines then, seems to be simultaneously jealous of Luxembourg, which has potentially broader protections, and emboldened by it. And because at the same time, very good cases are being brought to Strasbourg, saying that Strasbourg has to change its approach to generalized violence. And again, I should give credit to Nuala for Sufi and Elmi, because it would never have gone right were it not for the Air Centre. And the overall impact is an extension of Article 3, I think an entirely appropriate and legally warranted extension of Article 3. So this seems to be sort of a happy story about interaction with different judiciaries, and certainly given that the source material wasn't tremendously promising, Article 15c being drafted in a very, very difficult and challenging way. It's not a bad place to end, but I'm not going to quite end there. I can't end on an entirely happy note. Because when you look at actually, well, how has Article 15c made a difference in practice? And I think then we have to give credit to UNHCR for doing and commissioning very good empirical legal work, looking at actual case files. What you see is divergence and a real reluctance to use the protections of Article 15c in Iraqi cases, in Afghan cases, and certainly from what I've seen of the practice since, in the very few Syrian cases that make their way to Europe, Article 15c is not making Europe more generous. Generous is the wrong term. Respond as they should to Syrian refugees either. Most of whom, just to echo UNHCR's view on this, are actually convention refugees anyway, without a doubt. There is persecution and there are convention grounds without any difficulty in Syrian cases. So I think I should leave it there. Thank you.
Thank you.
Okay, fine. I'll see you in a minute.